Shima. I will now call the case of State of Kansas versus Nicole Willard. It's case number 125812. Counsel, you may approach. And Mr. Koch, whenever you're ready, you may begin your argument.
Thank you. Before I begin, are there any questions about the facts? That they weren't particularly complicated here. Yep. So this whole issue on appeal, what the court is, or what the state is seeking to have the court overturn from the Court of Appeals is whether or not Nicole Willard was seized and searched during a welfare check. The state's argument here, as it was at the Court of Appeals, is that she was neither searched nor seized. What had happened there was law enforcement arrived pretty quickly. By the time law enforcement got there, and by law enforcement, I mean the police, there were firefighters on scene already, and they had already made contact with Miss Willard. They then gave the officer her name, which the officer pretty much immediately stepped aside and ran for warrants. Warrant hit, and when the welfare check was concluded, she was taken into custody on that warrant. From the state's perspective, there are no material facts at issue here, so the court's review should be unlimited. The reason the state's arguing that she wasn't seized initially was because the officer who responded never had any direct contact with her until she asked some questions about where she was.
What about, you're focusing on the officer, and the officer, I think most have watched the video.
Yep.
It's pretty detailed, at least the officer's encounter with Ms. Willard. What about just the welfare check itself? Do we look at whether or not she was seized at the time the three firefighters approached, again, how you characterize it, surrounded her, were giving her aid, however you want to characterize it. Is one of our inquiries is that, was she free to leave at that juncture?
I think that's an inquiry that should be made, because even though firefighters aren't per se law enforcement, if they step outside their role and start engaging in investigatory, like criminal investigatory functions, as opposed to health investigatory functions, which was what they were there for, then yeah, they could certainly be government actors from that perspective, but that didn't happen here. And as to their proximity to her, I don't know if that's normal or not. I don't know how many they deployed to do that. But I agree, there were three and they were close to her. But I don't think they ever started investigating civil wrongs or crimes. They were doing what they were sent there to do. So it's something for the court to consider, but I think under these facts, no, they were not acting in a law enforcement or any kind of an enforcement capacity at all. So they do stand close to her. They get her name. One of them, Captain Arndt, steps aside and gives that name to, I don't keep rehashing the same ground here, but that's pretty much what happened. Then Sergeant Long, he never got within 3 yards of her, I don't think. He ran her name, and he let we let the firefighters continue. EMS shows up and they take over, but he doesn't interfere with what they're doing. He doesn't go through any of her belongings or anything like that. He just waits until she's done and then he takes her into custody. So so from the state's perspective, she was never seized by either the police or the first responder, firefighters or EMTs at all. And she was never actually searched because he didn't go through any of her belongings. He didn't search her. There was no Terry type pat down here. He didn't rifle through anything that she had. He just let the firefighters do their business, and then he took her into custody. And she doesn't really have any privacy interest in law enforcement's records. They aren't her records. They are records about her, but they're not her records, as opposed to, say, health records where the person actually has an interest in them and maintaining the privacy. So as long as law enforcement wasn't using them for something just beyond the pale, she wouldn't have any privacy interest in that anyway, nothing that's cognizable by the Fourth Amendment, and therefore she wasn't searched. And since she was neither searched nor seized, the trial court was correct when it denied her motion to suppress, and the dissent in this case, which was pretty well written, was also correct. I think the Court of Appeals erred in finding that she was seized and searched.
What function, shortly after the officer arrived, one of the firefighters took his clipboard, showed him her name, pretty much in response to some inquiry that she was critical about the firefighters, and gave her. And within 2 minutes or 3 minutes of him being there, he called in the warrant. What function does calling in an inquiry about a warrant do? Was she, let's say I want to leave, and before the results of the warrant request is made, could she have just left?
Yes, I don't see why she couldn't have. Assuming the firefighters had determined she wasn't a danger to herself or others, I think she could have just gone ahead and left, but she didn't. Sorry, was the question of what purpose did the warrant check serve? And
Yeah, I mean, just in terms of her ability to leave.
Oh, I see. I don't think.
And to voluntarily leave. Once that warrant is called in, could she just leave?
Yeah, I mean, there was no indication under these facts that Sergeant Long was restraining her or holding her there until the warrant check was done. So yeah, she could have left.
Excuse me, I'm having a little trouble. I've been trying to focus on the EMTs with this encounter because it looks to me like the safety check protocol, and I think there are references to this in the facts, are, the firefighters got there first, so they check a pulse, all that, but they really don't assure themselves that she's well, that she's okay, until they do the pass off to the EMTs, which in my notion of events was kind of the last thing that happens, the third thing that happened, because you got the firefighters, you've got Officer Long showing up, and then you've got the EMTs. Yep. And so am I reading that correctly?
Yeah, I believe so. I don't think, I imagine it has to do with proximity to where the call came from, because everybody isn't located equidistant from the call. So the firefighters got there first. I don't think that was by design. I think it was just how it shook out. Then Sergeant Long shows up, and by the time he gets there, they're already talking to her. And then the EMTs also show up. I assume that, and that was not in the facts, but I don't think the firemen are going to put her on their fire truck and take her to the hospital if that's the way it shakes out. They need an ambulance to transport her, and that would be the EMTs.
There's a reference, though, in the material that I wrote down that said that typically this is the EMT function in order to sign off on that this person is okay, which is the purpose of the encounter.
Right.
The other question I have with this is, what role, if any, does the fact that this is occurring on highway easement, it's under a bridge, the only reason why people are allowed in that right of way is for movement,
traffic
purposes. And so what role, if any, should we put to that?
Well, I think it's significant that it's not a vehicle stop and it's not searching someone's house. This is basically public property. Law enforcement had a right to be there just as she did. I think she was squatting under that bridge based on the facts here. Her stuff was there with her, but it certainly wasn't her residence. And the fact that it was public property, and it was, in fact, I think there were pedestrians who found her and called in the welfare check. It was certainly unusual for somebody to be not awake. I don't know if she unconscious or asleep or whatever she turned out to be. She certainly wasn't awake under that bridge. And so I think the fact that she was on public property would certainly reduce her expectation of privacy compared to, say, her house or a vehicle that was stopped.
I'm wondering so she gets on the phone to call the friend to come and pick her up. It seems to me that this encounter is going to have to last at least as long as it takes her to leave the public easement, because she's not allowed to camp there.
Right.
She's got to be in transit. She can walk there, but they can't just walk away from her when she's under a bridge. So in other words, they're going to have to watch her walk off the property and move on.
Make sure she's going somewhere else. Yeah, I would agree with that. Yeah, I really don't think you can just start camping under a public bridge. Yeah, they would have had to. She had called someone apparently to come and get her. That never actually happened, but presumably she would have stayed there until her ride showed up, because she was saying she didn't know where she was. So Sergeant Long had to say, "This is about where you are." Then she calls her friend to come and get her, which never happens. But unless she was just planning on wandering on off down the road and hoping her friend could find her, she would have stayed there regardless of what they did until her ride showed up.
It seems the panel at least put some weight on the fact that she refused treatment along the way, as I read the opinion, suggested, at least the panel majority, that then would end a public welfare encounter. But is that correct? Or does the defendant have complete authority to terminate a public welfare check?
Ultimately, I would say no, because if she was, again, when they arrived, they had no idea why she was there. As Judge Schroeder at the trial level pointed out, she could have been bit by a snake. I mean, there were many things that could have happened, including the fact that she was asleep under that bridge because she was trying to suicide. And so I think the EMTs had to at least make sure she was in a right frame, or the firefighters had to make sure she was at least in a right frame of mind to know she wasn't going to hurt herself or somebody else. And once they were convinced that she was in a position to knowingly, voluntarily, and intelligently refuse treatment, then yeah, that would have been the end of it. But this whole thing, again, I think it took less than 7 minutes from beginning to end. And Sergeant Long had made that call within the first 2. So I think I think she was probably stuck there until they had determined that she knew what she was doing as far as refusing treatment went. But I still don't think that rises to the level of a seizure as far as the Fourth Amendment goes, because that was the firefighters doing it for a valid reason, which was her welfare.
Was it ever articulated or explained to anyone why the warrant check was made? It just, in Ellis, we made pretty clear that a welfare check can't be utilized for other purposes, other investigatory purposes. So what was the purpose of running the warrant check at that time?
Well, Sergeant Long indicated that was something he did whenever he went to such calls, or when he made contact with people, he would just automatically call in the warrant check. But that was the reason here. But I don't think that really, his subjective reason for doing it, I don't think matters. If you're looking at an objective analysis, was that an objectively reasonable thing for him to do under those circumstances? The state would argue that it was.
Why?
Because they don't know, again, they don't know who they're dealing with. They don't know if this person is a violent sociopathic murderer who's wanted for like 10 counts of murder, or she just some poor person who just fell asleep under a bridge. They don't know, and they're putting.
So they don't know, so they investigate, right?
They consulted their own records to find out if anything was in there.
Why is that? Is that relevant?
I think I don't inject too much myself in here, but I work in a big stone building that has armored guards and metal detectors to keep me safe while I'm working. Law enforcement and the EMTs don't have that luxury. They're sticking themselves in harm's way.
I'm asking a more
I'm sorry.
basic question.
Oh, sorry.
I'm asking a more basic question, which is is there any constitutional implication to a law enforcement officer running a name for a warrant check?
From the state's perspective, no, because it's their record. She has no privacy.
I guess that's why I'm asking, why is it relevant? Why does it matter whether it was reasonable or not? There's no constitutional right not to have your name checked for a warrant, right?
That is true, but this is a Fourth Amendment case, and as I'm sure you hear in every Fourth Amendment case, the touchstone of the Fourth Amendment is reasonableness, and so I argue from that perspective. But I don't think it really matters because it wasn't a search anyway. Oh, I see I'm out of time. Thank you.
Thank you. Any other questions? Thank you.
May it please the court. When state actors perform community caretaking functions, the Fourth Amendment requires that their actions be totally divorced from the detection, investigation, or acquisition of evidence relating to the violation of a criminal statute. Relying on that principle, this court has held for more than 3 decades that state actors may not use public welfare stops for investigative purposes. Specifically, this court has held that an officer may not run a warrant check on a person seized for a public welfare stop unless that officer has reasonable suspicion criminal activity is afoot.
What's the authority for that statement?
Ellis, in your analysis on the purposeful and flagrant misconduct, because I'll admit Ellis could be used to stand for both propositions. One, you can't extend it, but also when we're looking at whether the conduct's purposeful and flagrant, this court has said that public welfare stops are not to be used for investigative purposes. And when this court said that, it distinguished it from investigatory detentions, which it's.
So you read Ellis to be that during a public safety encounter, no warrant check can occur,
Yes.
period.
That is correct. And the reason why is
Ellis doesn't do that. I don't, I mean, I reread Ellis about 3 times in the course of this case. You know, there, the officer took the driver's license and kept it in order to do things. This isn't anywhere close to that.
So I'll say, if this court holds that an officer can per se run a warrant check during a public welfare stop, you're going to dissolve the boundary between public welfare stops and investigatory detentions. What we allow in public welfare stops is seizures without any suspicion of criminal activity. The reason we allow these is because they cannot be used for investigative purposes. If all of a sudden we're allowing officers to seize people with no suspicion of criminal activity, but with no suspicion, they're allowed to investigate whether they're wanted for a crime, all of a sudden you have, because public welfare stops right here, it looks like a Terry stop. She is surrounded by state actors. Like a reasonable person would not have felt free to stand up and walk past 4 state actors surrounding them. And all of a sudden we're going to say, despite the fact that none of them had reasonable suspicion that she was committing a crime, they can hold her there and investigate whether she is wanted for a crime.
Is that what happened though? I don't know that that's what happened. And the reason I say that is because, again, looking at that videotape, in my mind, they can't be assured that she's okay until the EMTs look at her. And that happened after the record check occurred. So there's no extension of the encounter. There's nothing other than the fact that on the periphery of this check, the officer asked for warrants.
Yes, so it didn't extend it, but the warrant check exceeded the scope of the underlying justification for the stop. Again, the reason the seizure is reasonable under the Fourth Amendment is because there is not supposed to be any sort of investigation.
In the dissent, Judge Gardner makes the point that for public safety purposes, the officers ought to know who they're dealing with. And doing a records check accomplishes that. It doesn't seem out of place.
So usually the cases she relies on are all typically traffic stops or other Terry stops. And the Supreme Court in Rodriguez recognized that ensuring officer safety is just part and parcel of a traffic stop because the person is being stopped for committed a crime. And so the negligibly burdensome warrant check is therefore just part of that mission. Whereas here, running a warrant check does not further any objective of the mission of the public welfare stop.
It helps protect the public employees that are there doing the record check.
But
right? I mean,
no,
by definition, it has to.
I disagree.
Otherwise, if this person is wanted for murder or, an armed offense, what's wrong? Again, I'm not trying to extend the stop because there's no suspicion. I'm just saying that in the course of this 7-minute period, the officer's off to the side and all he does is call in on the radio.
Yeah, he investigates whether she's wanted for a crime. And as the Supreme Court recognized in Strife, and this court has recognized as well, when the officer knows that she has a warrant out, he has a duty to arrest her. And so there is the argument that there's officer safety, but you can't extricate the investigation part from the warrant check. And that's the problem here, is that they have no evidence that she poses any danger. Yet we want to say that anytime someone is seized for a public welfare stop, the officer can investigate them.
Aren't we sort of begging the question? Isn't the question whether or not she was seized?
I mean, yeah. Well, I mean, that's where we have to get that.
You've referred to this several times as a public safety stop,
Mhm.
and the word stop tends to be a term of art in this context,
Mhm.
which means seized for Fourth Amendment purposes.
Yes.
There's not always a quote unquote stop or seizure with a public welfare check, correct? Every public welfare check does not result in a seizure.
That's right. They could be voluntary encounters. It could be a welfare check that's a voluntary encounter. But we also recognize that we can have public welfare stops that are seizures, like pulling someone over despite they haven't committed a traffic infraction.
So the analytical path here would be, first, was there a seizure? And then Secondly, was the seizure unlawfully extended? Did the officers exceed the scope of the purpose for, isn't that right?
Yeah, so the preliminary question, was there a seizure at all? I agree with that. And then the question is whether the officer, by running a warrant check, exceeded the
And that's
scope.
the only way to get the warrant check thrown out, essentially. There's no, in other words, I'm sort of circling back to Justice Biles's question. There's no bright line rule that says you can't do a warrant check, period, on when you get a name, just because it was in the context of a public safety or a welfare check.
I just strongly disagree. I read Ellis a lot
What
this
would be
weekend
the
too,
constitutional grounding of that rule?
because
You have a voluntary encounter, it's a public welfare check,
Mhm.
and the officer gets a name and decides to run a warrant check. What in the Constitution would prohibit that?
well, so I'm basing public welfare stops as seizures, when they're seizures. So when I'm used the term public welfare stop, there's a seizure. That is, the person is not free to
That's
leave.
different from a bright line rule that simply says you can't run a warrant check when you're doing a public welfare check.
So public welfare check, if it's a voluntary encounter, but running the warrant check could change the nature of it. If this person is accepting the services and then all of a sudden the officer runs a warrant check and then she gets up to leave and they say, no, you need to stay here while.
Let's say you have a voluntary encounter, an officer goes to a home, they've been called and said, we haven't heard from our friend in a week. We want you to check. And the officer goes up and knocks on the door, checking on your welfare. The person answers and says, oh, no, I'm fine, you know. And the officer gets that person's name, goes back to their vehicle and runs a warrant check on it. What's wrong with that?
I don't think there's anything wrong with that.
Okay.
My problem is when there is a seizure, and that's what happened here.
So what you're really talking about is an unlawful extension of a stop
That's correct.
to perform a warrant check.
And so when we talk
Right.
about extensions, I don't mean it in lengthwise, because if that was the case, then this would be on all fours with Ellis. I guess I'm going outside the scope, outside the bounds of what we allow.
You're saying that even when the stop is lawfully enduring
Yes,
to fulfill the public safety purposes, the officer still can't do a warrant check during that period of time.
that is correct, because then it would transform.
Doesn't that contradict a lot of our case law about, for example, when officers can call a drug dog? When they make a lawful stop, we have case law that, we have a lot of case law that talks about you can't unlawfully extend the stop beyond the initial reason for the stop.
Mhm.
Can I follow up on that question? So is part of the problem here that the testimony from the officer was simply, I always run these checks. It's a matter of routine. And the testimony wasn't, well, I was concerned about whether the responders were going to be safe, or we didn't know if she was intoxicated or dangerous. There wasn't any of that kind of testimony. Is that part of the problem here?
I guess it'd be a problem for the state in that, like, their idea that we need to run this in order for, public safety purposes, because as the Court of Appeals recognized, there just was no evidence that she was dangerous. But I'd still disagree that if they're like, well, we thought she was dangerous, I think warrant checks just rarely, if ever, will tell you whether or not someone's dangerous. In this case, there's a warrant out for her because of a probation violation, for a technical violation, I believe. And so the evidence in this case kind of defeats their own argument. She did have a warrant out that they found out, and she wasn't dangerous. Long even said during the stop that she was, for the most part, cooperative. But Justice Siegel, back to your question about dog sniffs, I'd actually disagree that you could run a dog sniff. Like, say in this case, if they brought a dog to sniff her backpack, I would say that would actually exceed the scope as well, because.
But for duration, right?
No, because again, going back to the language in Katie, when you perform the community caretaking functions, your actions have to be totally divorced from the detection, investigation, or acquisition of evidence relating to criminal statute. The only
you are wanting this court to draw a distinction between different kinds of seizures. In other words, there's a seizure That is, I pull over a vehicle because they didn't use their turn signal
Mhm.
versus a seizure that was initiated by a welfare check.
Exactly, like saying Gonzalez, like the wheel was kind of loose. If you pulled him over to make sure that was fine and you ran a dog around it, all of a sudden you're not stopping them to make sure that they're, safe. I think it was Mesner was the Court of Appeals case where a person was acting erratic in a grocery store, gets in his car, drives, the cop pulls him or the officer pulls him over and then runs the warrant check during that. And it says that just exceed this.
Once there's knowledge of a warrant, Officer Long has the knowledge of a warrant. What was he supposed to do once he acquired that knowledge? Is there some suggestion that in order to preserve the evidence that was in her pocket, I think is where they found the drugs, the methamphetamine, should he have waited until she gets up and leaves, and that would cure any kind of nexus between the community care function and the investigate? I mean, or what if he knew? I know her; she has a warrant. What if he would have walked up and known that? How do you? What's what in a practical way? What was he supposed to do?
And so I just go back to I like that language in Cummings versus Missouri, like that, that you can't do indirectly what you can't do directly, and that the Constitution deals in substance, not shadows. And so the idea that the Fourth Amendment is some game with loopholes.
I agree, but there is, like you said, once a warrant is issued, he has the duty to execute that warrant.
That is exactly correct. And so if he has no reasonable suspicion that she was committing a crime, is committing a crime, or is about to, then the only reason he's running that warrant check is to see whether he needs to arrest her, which is why I believe that it is investigatory.
I want to go back to Justice Wall's question to the state. Does the defendant, Ms. Willard in this case, have the sole authority to end a safety check?
So I've had some people disagree with me. I'd say no. Again, if someone was shot, is bleeding out, they say, leave me alone. And the officers say, just walk away. And the next day the person's dead. And because EMS was told to walk away, I think it's reasonable if a person's in a bad situation and officers
Or in any situation. But how do you're wanting there to be blood in your example. I'm just saying, you don't know.
No, I think it was fine. I think the duration of this was fine. It was reasonable to make sure she was fine. The problem I have with it is just the actions taken during it.
So you are, and I wrote it down here. Your whole complaint here is that a public safety check can only have one purpose. And it is a violation of the Constitution if anybody around there does any other purpose, regardless of whether it's extended or anything else.
Yes, this court had,
and so you've cited Katie and that term totally divorced, which I looked up this morning. And it only happens once in Katie. And it's in the context of simply trying to say, in law enforcement, there can be two different functions. One, is traffic stuff, doing a traffic accident and that kind of thing. And then the other is criminal investigation. But it never adds the verbs that you add, which is to say you can never, that the totally divorced language is just saying there are these two different functions. It doesn't have anything to say that there can't be an overlap of those purposes, provided it doesn't extend the stop. It doesn't say that.
okay. Mr. Chief Justice, I see I'm out of time. If I can answer a question. So as a preliminary matter, this is different from your question. You had asked about whether there's highways, easements and everything like that. So I wanted to address this. I'm not an expert, but I did look at the Hutchinson Municipal Code. Nothing in there would have covered what she was doing. So it wasn't like she was breaking some city ordinance. But I absolutely do agree that, or it's not agree, but I stand firm that this court allows seizures without any suspicion of criminal activity. And what we're saying is, as long as we don't extend those, we can still investigate somebody. If this is what that court holds, you have created Terry stops without any reasonable suspicion of criminal activity. That is why it must be divorced from the investigation of violation of criminal statute.
But this gets back to Justice Steele's point, though, that during a traffic stop, as long as it doesn't extend it, they can call into dispatch and say, what do you know about this person or in this car tag?
Yeah, because during a traffic stop, there's reasonable suspicion or even probable cause that a criminal law has been broken. When we seize people for public welfare stops, there is no suspicion that there is any criminal law that has been violated. And so allowing officers to use the stop as a means to still investigate that person when they are not feel free to leave.
But again, you've added words to you're saying when they use the safety stop as a means to, and I don't see where he used this as a means to. He was just standing off to the side while the firefighters did their thing, waiting for the EMT guys to show up. And he just gets on his radio and runs a record check.
She was seized. She was not free to leave for the purposes of to see whether or not she's okay. And he ran a warrant check, which let him know whether she needed to be arrested. He investigated whether she needed to be arrested, despite the fact he had no reasonable suspicion that she had committed any crime. So unless the court has any further questions, we'll simply
Any
ask.
other questions, colleagues? Thank you very much.
Thank you.
Mr. Coke, you reserve 5 minutes.
I think I'd like to point out at the outset that looking for a warrant isn't evidence of a crime. A warrant is an order from a judge saying, I want to see this person and I want law enforcement to bring them to me. It's not, that's not evidence of anything other than the fact that some judge wants to see someone for some reason. I don't think that's running a warrant check isn't investigating a crime. The crime already happened or allegedly happened. It's not new evidence of anything other than the judge wants to see somebody. And so I don't think that by running that welfare check in any way could be characterized as a criminal investigation. Even on top of the fact that, like I said before, she doesn't have any privacy interests in their records.
Well, okay, so this question's going to sort of circle all the way back to a theme that's run throughout, which is this question of, can a person unilaterally end a welfare check? And your opposing counsel articulated his argument to be, I think, that, look, if we're going to let the government seize people with no evidence, not even any suspicion of criminal activity, simply for their own welfare, that we really need to impose serious restrictions on that kind of a seizure so that it doesn't bleed into basically the whole fishing expedition thing that reasonable suspicion is intended to stop, right? That's the argument. I want to dig into that a little bit and just query whether or not, is that true? Can the government seize a person purely for a welfare check? It's sort of the flip side of asking the same question about, could a person unilaterally end a welfare check?
Right. Yes, they can seize you for that. I'm not saying it is.
What's the constitutional grounding for that? In other words, why wouldn't the Fourth Amendment just carte blanche prohibit that?
It's because they're not investigating a crime and the government isn't.
It doesn't matter. What business is it of theirs? What business is it of the police whether or not I'm okay?
If you end up in a situation, and there are an infinite number of welfare check possibilities, but just to focus on one, which is not what happened here. If a person is out there behaving erratically, they could be in such a state that they're going to harm someone else. And that we do have an interest in protecting each other.
That's reasonable suspicion.
Not necessarily, because I guess you could say they harm themselves as well. But yeah, I mean, as a society, do we have an interest in making sure nobody's going to just.
So we just set the Fourth Amendment aside? I mean.
I understand what you're saying. I don't know if the government really has, what interest the government has in me.
I can see that
doing harm to myself.
A reasonable, rational, prudent purpose of law enforcement to say, you can initiate any voluntary encounter you want. I mean, police officers can come up on the sidewalk and just say hi to you. What do you think of the weather today, right? If it's a voluntary encounter for a welfare check, fine. But the question is, can they seize a person simply to do a welfare check?
Yes. Because so you come back to a care and treatment, which is not a crime, it's a civil thing, but they still seize you for it anyway, and they take you in.
Well, that's governed by statute.
Yes.
I-
Maybe I misunderstood the question.
Your admission that the government can seize somebody for a welfare check strikes me as pushing this case a long ways towards the defendant's argument that we need some serious protections if that's the case.
I understand, but I have to answer honestly, and that's what I think.
I understand. Thank you.
Any other questions?
Is there any limitation on an officer or those empowered to check for warrants?
Not that I can find.
So an officer can go into a store, see a name tag on a checker and say, I don't know, I'm going to run your name for a warrant check. And that's okay.
Yes.
Or anywhere, just at any time, anyone is subject to a check of a warrant based on anything.
If the officer knows your name, then yes, they could run you for a warrant check. At least I can't find anything that says they can't. Short of having the person commit another crime and then executing your warrant, I think that's about your best way is through encountering them in public. I suppose you could send out a warrant squad to knock on their door, hoping they're home to get them. But short of that, yeah, that's how they get most people. Is they run into them out on the street, and they find out who they are and they execute their warrants.
Any other questions, Collins? All right, thank you very much for your arguments this
Thank you.
evening, counsel. We will take this matter under advisement